The Supreme Court just dropped a 54 ruling that every single gun owner in America needs to hear about right now. You pull over. The officer walks to your window and says the words that change everything. Step out of the vehicle. And every single day, drivers make one costly mistake. In that moment, they open the door without saying a single word. That silent exit hands officers legal tools most drivers never realize they just gave away. After analyzing hundreds of traffic stop cases and studying the case law that governs these encounters, I have pinpointed the most dangerous window of the entire traffic stop. It is not when the lights come on. It is the 15 seconds before your foot touches the pavement. I will show you 5 exact moves that protect you in that window. And I will give you the precise phrases to say before you ever reach for that door handle. Stay with me, because mistake number 3 is the one that shocks people most when they hear it. This is educational content only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Mistake number 1 is not knowing whether the officer is asking or ordering you out. Picture this. The officer leans into your window and says, "Hey, can you step out for a second?" And you step right out. Most people do not realize they just gave something away. The word can is not a command. It is a request. And legally, those two things could not be more different. Under Pennsylvania versus Mims from 1977, officers can order a driver out of a lawfully stopped vehicle for officer safety. But that authority only applies when they are giving an order. A request carries no such authority. When you comply with a request, your exit looks voluntary on the body cam. Courts have repeatedly characterized voluntary exits as implied cooperation with broader interactions that follow. The question you ask before touching that door handle, officer, are you asking me or ordering me to step out of the vehicle? Say it calm, say it polite. That single question forces the officer to put their actual authority on the record captured by their own body cam and yours. If they are asking, you can decline. If they are ordering, now you know your legal situation, and you move forward from there. Here's the dialogue. Wrong way. Officer says, "Can you step out for a second?" Driver opens the door. Silently. That is an apparently consensual exit on camera. The officer has not made any order and has not put any legal basis on the record. But the body cam shows what looks like a driver who cooperated fully, which opens the door for arguments about consent to everything that follows. Right way, officer says. "Can you step out for a second?" Driver says calmly, "Officer, are you asking me or ordering me to step out of the vehicle?" If the officer says it is a request, the driver can politely decline. If the officer confirms it is an order, the driver says, "And for the record, what is the lawful basis for that order?" The officer either articulates officer safety, which is their authority under MIMS, or reveals they have no clear legal basis at all. Either way, it is now captured. Driver now has legal clarity locked into the record. Remember this phrase. Say it 3 times. Officer, are you asking me or ordering me to step out? Officer, are you asking me or ordering me to step out? Officer, are you asking me or ordering me to step out? Bottom line on mistake number 1, never open that door until you know whether you face a request or an order. That single question changes the entire legal dynamic. Now here is what most people miss. Knowing the difference between a request and an order protects you in that one moment. But the Supreme Court has ruled that your Fifth Amendment rights do not activate automatically. There is a critical gap between asserting your Fourth Amendment protections and protecting yourself against self-incrimination. 2 landmark cases expose this gap. Salinas versus Texas from 2013 and Berghaus versus Tompkins from 2010. Mistake number 2 is falling directly into it. Mistake number 2 is staying silent without explicitly invoking your right to remain silent. This is the legal rule that makes people furious, and they should be. In Salinas versus Texas, the Supreme Court ruled that when a person goes silent during non-custodial questioning, meaning questioning during a traffic stop before any arrest, without explicitly invoking the Fifth Amendment, prosecutors can point to that silence in court as evidence of guilt. In Berghaus versus Tompkins, a suspect sat through nearly 3 hours of interrogation, mostly in silence, then made one brief statement. The court held he had waived his rights because he never clearly invoked them. The combined rule, you must speak to protect your right to be silent. Silence without invocation is not a shield. It is a weapon prosecutors can pick up and use against you. Before you open that door, here's what needs to be on the body cam. Say clearly and calmly, "Officer, I am invoking my Fifth Amendment right to remain silent. I do not consent to any searches of my person, my vehicle, or my belongings, and I am requesting to speak with an attorney before answering any questions." 3 sentences, 15 seconds. Legal architecture documented before your foot hits the ground. Here is why every sentence matters. Invoking the fifth explicitly satisfies Salinas and Berghaus. Declaring no consent to searches protects you under the Fourth Amendment, because under courts examine the totality of circumstances for consent, and passive compliance has been repeatedly treated as implied consent. Requesting an attorney signals your Sixth Amendment awareness and creates documentation that protects you if the stop escalates the wrong way. Officer orders driver out. Driver exits silently. Officer asks, "Where are you heading tonight?" Driver answers. One answer leads to another. Driver reveals they had drinks at dinner the right way. Before the door opens, driver says, "I invoke my Fifth Amendment right to remain silent. I do not consent to any searches. I'm requesting an attorney." Driver exits. Driver stays quiet. Remember this phrase 3 times. I invoke my Fifth Amendment right to remain silent. I invoke my Fifth Amendment right to remain silent. I invoke my Fifth Amendment right to remain silent. Bottom line on mistake number 2. Silence alone is not constitutional protection. The Supreme Court requires an explicit verbal invocation to shield you. Say the words before you open the door. You have now protected your right to silence and your right against unreasonable searches. But here is the gap most drivers never see. Your exit itself, the physical act of stepping out, can look like voluntary cooperation unless you document one more thing before your hand touches that handle. And this is the one that surprises every person when they first hear it. Mistake number 3 is stepping out without announcing your compliance. 3 seconds. Before you open that door, before your hand even touches the handle, one more sentence needs to be on the record. Here it is. I am complying with your order under protest, and my hands will remain visible at all times. This phrase does 3 critical things at once. First, it establishes your exit as compelled, not voluntary. Voluntariness is central to how courts evaluate everything that happens after the exit. A compelled exit, documented by your own words, eliminates the argument that you were freely cooperating beyond the legal minimum. Second, the phrase under protest is a legal flag that any reviewing court will recognize. It signals you are not a willing participant beyond what was required of you. Third, announcing that your hands will remain visible eliminates any officer claim of furtive movements that could justify a pat-down. Here is how the body cam footage works against silent drivers. Without your verbal declaration, the footage shows a door opening, feet on pavement, body stepping out. It looks cooperative with your declaration. The footage documents this person exited under legal compulsion, under protest, with hands visible throughout. That is evidence your attorney uses at a suppression hearing to challenge anything that happened after the exit. And here's the detail most legal content overlooks. Close the door when you step out. When you exit and leave the door open, you dramatically expand what falls under the plain view doctrine established in Horton v. California from 1990. Officers can observe your interior from new angles. A flashlight sweep is not a search under the law. It is plain view observation. Anything visible from their lawful position can be seized without a warrant. Closing the door limits that exposure and forces any further observation to require a legal basis beyond plain view. Say it 3 times. I am complying under protest, and my hands will remain visible. I am complying under protest, and my hands will remain visible. I am complying under protest, and my hands will remain visible. Bottom line on mistake number 3. Your exit must be documented as compelled, not voluntary. Announce compliance. Declare protest. Close the door behind you. You have protected the exit and limited visual access. But once you are standing outside, a completely different set of legal rules applies to your person. The Supreme Court addressed this in Arizona v. Johnson from 2009, and what the court held connects directly to mistake number 4. Mistake number 4 is answering questions while standing outside the vehicle. Once you step out, the environment changes completely. Officers are trained to use that environment. You are exposed. The patrol car lights are on you. Body cameras are running from multiple angles, and officers will ask friendly conversational questions. How are you tonight? Long drive. Where are you coming from? Drivers answer because standing roadside in that pressure. Silence feels like guilt. Here's what the law actually says. Under Rodriguez v. United States from 2015. Once an officer has completed the tasks tied to the traffic stop, checking your license, registration, insurance, and issuing or deciding on a citation, the legal justification for your continued detention is complete. Any continued questioning requires independent, reasonable suspicion. Every answer you give provides potential material to establish that suspicion. The escalation when you answer plays out like this. Officer asks where you are coming from. Driver mentions dinner with friends. Officer asks if you had anything to drink. Driver says just one beer. Stop is now a DUI investigation. Officer asks if anything illegal is in the vehicle. Driver says no. Officer says, well, then you do not mind if I take a look. Driver is now in the consent trap. The body cam recorded every word of every answer that built that case the right way. You already invoked your Fifth Amendment right to remain silent before you stepped out. Every question the officer asks after that, you respond the same way. I have invoked my right to remain silent. Calm, firm, polite, no attitude, no sarcasm. Do not match aggressive energy. Do not raise your voice. Stay calm, stay polite, but stay firm. Cooperation does not mean conversation. You can be completely respectful to an officer while exercising every constitutional protection available to you. When you believe the stop should be complete, ask this question. Has the purpose of this stop been completed? Am I free to go? Under Rodriguez, asking that question on camera forces the officer to either release you or articulate a new legal basis for holding you. If they have no basis, that is now documented. Say these words 3 times. Am I free to go? Am I free to go? Am I free to go? Bottom line on mistake number 4. Every answer outside that vehicle is potential evidence. Your pre-exit invocation protects you, but only if you actually stop talking. Stay quiet. Stay protected. One more critical point before we close. Officers are legally permitted to lie to you during a traffic stop. They can claim to have evidence they do not have. They can say a witness identified you when no witness did. They can tell you cooperating will make things easier when legally it changes nothing about their authority. This is why your invocation matters so much. It is not because you have something to hide. It is because you genuinely cannot know what they believe, what they claim, or how they will interpret anything you say. The only safe response after invoking your rights is to say nothing further except I invoke my right to remain silent. I want an attorney. Mistake number 5 is failing to execute the full first 30 seconds properly before you ever exit. The first 30 seconds of any traffic stop are the foundation every subsequent right rests on. Here is the exact protocol. Pull over safely using your turn signal. Turn on your dome light if it is dark outside. Turn off your engine. Place both hands on the steering wheel where they are visible. Roll your window down 2 to 4 in only. Do not open the door until you have determined whether you face a request or an order. When asked to provide documents, announce every movement before you make it. I am reaching into my glove box for my registration. My hands will stay visible. Then say your 3 sentences before you open the door. The first sentence, I invoke my Fifth Amendment right to remain silent, and I do not consent to any searches of my person, my vehicle, or my belongings. The second sentence, officer, are you ordering me to exit? And if so, what is the lawful reason for that order? The third sentence, I am complying with your order under protest, and my hands will remain visible. Then step out, close the door, stay quiet, ask when appropriate. Am I free to go? Remember your 4 core phrases. First, am I free to leave? Ask it early. The answer determines what legal situation you are in. Second, I invoke my Fifth Amendment right to remain silent. Say it explicitly before you open the door. Silence alone is not enough under Salinas and Burgess. The words must be said. Third, I do not consent to searches. Say it clearly, covering your person, vehicle, and belongings. Fourth, I want an attorney. Say it before questions begin and before any arrest. Now, 2 state-specific notes because the law varies and general knowledge only gets you so far. In stop and identify states, including Texas, Nevada, and Colorado, you are legally required to provide your name when lawfully detained. Refusing can result in a separate obstruction charge. This is worth repeating. In these states, giving your name is required. It is not a rights violation. It is state law. In non-stop and identify states like California and Oregon, you have broader protection and can decline to identify without creating a separate legal problem. Regarding marijuana as probable cause in Colorado and Maryland, courts have significantly limited the use of marijuana smell alone as a basis for vehicle searches. In Texas and many southeastern states, the odor of marijuana still provides probable cause for a full vehicle search under current case law. And regarding window rolling requirements, most states have no specific statute on how far you must lower your window during a stop. The 2 to 4 in approach is a practical standard that allows document exchange while limiting plain view exposure inside your vehicle. Know the specific rules in your state. This is educational analysis, not legal advice for your situation. This is educational content only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. Here is the core principle of everything in this video. The 15 seconds before your foot touches the pavement are the most legally important seconds of your entire traffic stop. Use them deliberately. Speak your rights into the record before you open that door. Your 4 phrases one more time. Am I free to leave? I invoke my Fifth Amendment right to remain silent. I do not consent to searches. I want an attorney. Now, here is the rest of your legal education. Multiple constitutional protections work together during traffic stops, and they have different rules for when and how they apply. I break down how those protections interact in different situations. In the next video, it is on screen right now. Click it to keep building your legal knowledge. Drop a comment with where you are watching from and what time it is there right now. It helps this channel more than you know. Remember, knowledge of the law is not confrontation with the law. It is participation in it. Stay safe out there, stay respectful, and stay protected.